My name is Jeff Servin. I'm going to be talking to you for the next hour and 45 minutes on a number of subjects, basically in two areas. One is litigation and one is financing. I do a lot, aside from my law practice, I do a lot of funding and financing from like $250,000 to $15 million and up. The central theme of what I'm going to talk about is that in law, and then actually in financing, there's a lot of BS. There really is. There's a vast gulf between the way people think they are and what they have to do and what reality is to basically do something, get it done, and get it closed. There's a lot of misconceptions about presentation. There's a lot of misconceptions about implementation. And what I've found is that is that keep it simple, stupid. Less is really more. In this day and age, with all of the data and everything, people have very, very short attention spans. You say to somebody, well, let me give you some background. By the time you're done the background, they're not listening to you anymore. So, sometimes the background, you wait on that until you actually do something. You want to be in a position where you make the right focus, make the right choice of what you're doing. You don't want to be in the position of, in a particular situation, where based on a historical perspective, you're in the situation where you say, oh, Mrs. Lincoln, other than that, how was the play? So you want to really sort of hone in on these things. Okay. What you have in front of you is kind of a 7-part presentation, which deals with both legal, litigation, transactional, and financing matters. And what I'd like to do, I want your questions, but my suggestion is that there's 7 different parts. Hold your questions until the end of that particular part, and I'll ask your questions, because some of the things you may be asking, I may answer. Okay. The first thing, on the second page, you'll see there's 2 things on it. It says how to avoid a bankruptcy, litigation, and strategic financing. So the first thing is a pretty common mistake that people make, especially in this day and age when economics are difficult, etc. And you're getting to the point where you think, oh, I may have to file for bankruptcy. The worst thing you can do in a situation like that is go to a bankruptcy lawyer. The problem with that is there's a lot you can do before that where you can avoid filing for bankruptcy. Bankruptcy, no matter what everybody tells you, stays with you for 10 years and can be an impediment. In my practice, I can buy almost anybody 8 months to a year without a bankruptcy. You should only be considering a bankruptcy because now you can do it electronically. If it's Tuesday and there's a sheriff's sale and it's one day before, and it's Monday, and all other situations have been exhausted. Basically, how do you do this? If you know the litigation system and you know how the litigation system works, you can slow any situation down. If you owe creditors, whether it's $50,000 or $50 million, you can use the legal system, the process of the legal system to your advantage. Let's take a mortgage foreclosure on a commercial piece of property. You've tried to adjust it, you've tried to deal with it, and now you know that you really can't do anything. But if you had 8 months to a year, something like that, maybe you could refinance it, maybe you could find a buyer, maybe you can do something where you don't have to file a bankruptcy. Technically, a mortgage foreclosure is a complaint, like any other complaint. And if you, especially, the last one I did like this was in Montgomery County, who was so slow. What you need to do is prevent a judgment being taken, just like any other complaint. And the simple thing you can do to prevent a judgment being taken once you get the notice of the mortgage foreclosure is you file an answer and just deny everything. Now, what that does, that prevents whoever the claimant is from taking a judgment, which stops the thing dead in its tracks. In Montgomery County, what they then have to do is the key to this is you don't ignore these things. It's like cancer. You catch cancer early, you can cure it. You let it go, it'll engulf you. So in this particular situation, I had a client of mine got served with a mortgage foreclosure. We filed an answer. Okay. Now that meant that the plaintiff couldn't take a judgment. He'd have to, in Montgomery County, and I don't want to get overly technical, but it's not that hard to understand. In order to get a judgment, and we didn't have a defense. You don't have to have a defense. You just have to put them to their proof. You're not misrepresenting anything. You're not doing anything illegal. You're just saying, hey, prove it. So in Montgomery County, once you file an answer, then they can't do anything. What they can do is file something called a motion for a judgment on the pleadings. In Montgomery County, to say, this guy has no defense, enter the judgment. In Montgomery County, usually for a complaint, you have 30 days, and when you file the answer within that 30-day period, it will take them 4 months to get a judgment on that motion for a judgment on the pleadings. By the time you get notice of it, it's another month. Now you're 5 months down the road. It's not necessary to file a bankruptcy yet. And then once that happens, if you want to buy yourself more time, you appeal to the Superior Court. You're going to lose, but that doesn't matter. That'll take another year. So now where you are is instead of having to file a bankruptcy, once you get notice of this, you have 1.5 years to work it out. Perfectly legal, happens all the time. Well, if you're at a certain age and you're still in business, you'd rather go that route than any other route. If you're 80 years old and you're not going to be in business anymore, then you can file a Chapter 7 and liquidate. But don't be so. The problem with a lot of bankruptcy lawyers, that's all they do. And and I've seen some horrible stories where bankruptcy lawyers have advised clients who are only like $20,000 in debt and they're 30 years old, file a bankruptcy right away. No, there's lots you can do to stop the train, and which then gives you time. Time is incredibly valuable. You can refinance, you can get a relative, you can hit the lottery, and in this example, when will we file a bankruptcy? You got a sheriff's sale coming up on 6 months down the road. You can file the night before. When you file the night before, it takes about 20 minutes. There's something called an automatic stay. That stops everything dead. Okay, and then you have to go into that process. And what you're trying to do is just buy time. The thing on the front page is one of my clients who I did that for. It bought us time, and we ended up working our way out of the problem. Whereas the other thing is you file a bankruptcy in most financing documents. There's a clause that says, even if you're current, even if you're paying them and you're current, that if you file a bankruptcy, it's an automatic default and collapses everything. So you really got to be careful of the ramifications of these things.